This is Counterpoint, and I'm your host, Tanya Allen. Tonight, we're taking a closer look at two new pieces of legislation which are raising serious concerns about privacy, surveillance, and government overreach in Canada. The first bill is called C2, also known as the Strong Border Act. And while its name suggests a focus on national security and immigration, digital rights advocates warn that it goes much further and much deeper than many Canadians realize. Tucked inside this expansive omnibus bill are provisions that would give police and intelligence agencies sweeping new powers to access Canadians' digital information without a warrant. This includes the ability to demand subscriber data, device identifiers, and online account details from internet providers, all based on what critics say is a dangerously low threshold of suspicion. For many, this marks a clear step backward for privacy rights in Canada. And then there's C4, the Making Life More Affordable for Canadians Act. Sounds pretty innocent, right? Well, buried inside is a provision which seeks to exempt political parties from the application of privacy protections retroactively to the year 2000. The provisions give political parties virtually unlimited power to collect, use, and disclose personal information with no ability for privacy commissioners to address violations. And the concerns aren't just about what's in these bills, but how they have been introduced and debated, if at all. Joining us tonight is Dr. Michael Geist, Canadian Research Chair in Internet and E-commerce Law at the University of Ottawa, and one of the country's leading voices on digital rights. Dr. Geist, thank you so much for joining us tonight. I appreciate your time.
My pleasure. Thanks for having me.
Well, let's start with C2. So what exactly is buried in C2, and why should Canadians be paying close attention?
Yeah, so buried at the very end of that legislation are what has long been referred to as lawful access rules. And we've had successive governments, both conservative and liberal, propose over the last couple of decades these kinds of rules, which essentially say under what circumstances can law enforcement obtain access to things like subscriber information or the information of Canadians, either with a warrant or in some instances without one. Now, there were efforts years ago to try to get this through, but the Supreme Court of Canada stepped in and in a couple of rulings has said that Canadians have a reasonable expectation of privacy. And as part of that, there's an expectation that you're going to need to get a warrant. The government is bringing forward this legislation with both creating a new warrant, so there is some warrants that will oversee some of the access, but at the same time also creating a new information demand power that would grant law enforcement the ability to demand access to certain information with no warrant at all.
Wow, that's shocking hearing you speak on this because I think most Canadians are really not aware of this. Now, it's titled Border Privacy Act, or sorry, let me rephrase that, the Strong Border Act. So I assume this has to do with securing our borders. So does C2, this bill, engage in data collection at the border?
No, this isn't about the borders, or at least these elements aren't about the borders at all. In fact, this applies as broadly as you can possibly imagine. Some of the earlier versions of lawful access, as I say, dating back to both liberal and conservative governments, focused on telecom and internet providers. The idea was, could you gain access to subscriber information from those companies? The government has expanded this as broadly as I think you possibly could by saying this will apply, this information demand power will apply to any provider of a service in Canada. So we're not just talking about telecom and internet companies. We're talking about physicians and lawyers and accountants. It could be your hairstylist or your gardener who gets captured by all of this. Certainly hotels and car rental companies. All of these kinds of service providers are all effectively captured by this information demand power, where they could face demands to disclose certain kinds of information, no warrant required.
And the impetus behind this bill is to what? To aid agencies, law agencies to apprehend potential criminals or criminals?
Well, it isn't just crime. Interestingly, this applies to any potential violation of any act of Parliament. So it's not just the criminal code either. Now, they're the kind of powers that law enforcement has long been looking for, and unsurprisingly, they're supportive of this legislation. But we have to recognize that they were supportive of this kind of legislation years ago when the Supreme Court of Canada said, hold on a second, disclosures like this without a warrant are inappropriate. You need to have appropriate court oversight. And so the government really seems to be shifting that aside, moving ahead now with these kinds of demands. And while they've tried to argue that the information that's at stake has limited privacy import, the reality is that some of it can be pretty significant from a privacy perspective, especially when you consider how broad-based and how broadly applied this legislation is.
Okay, we're going to get into some of those details when we return from this commercial break.